But yeah, Mr. Norris, want to tell us a little about your Carlock, Copeland, and about yourself?
Yep. Yeah, y'all feel free to just grab whatever, and by all means get up and get more pizza in the middle. It's not going to hurt my feelings. My name's Patrick Norris. I'm a defense litigation attorney. I also do some contract type work, but 95% of what I do is with design professionals, with architects and engineers. So we do everything from helping people negotiate contracts, write contracts, review them, handling pay disputes, and then if the project ends up in litigation, construction defects, design defects, you guys end up on the wrong end of that stick, get sued, then we step in and defend you guys. So I'm friend, not foe, so all lawyers are not bad, just say that. Chris said that I would tell you everything you need to know about the legal side. I will not guarantee that, but I can tell you some of what I've picked up over the multiple years that I've been doing this, and sort of some stuff to avoid. And what I thought we might do is start with sort of our outline for the talk would be contracts, what you need for a good contract, what are some bad provisions that you see and you want to avoid. And then that'll take us into how do we handle disputes when they arise, and then ultimately we'll talk about some real world litigation type stuff. There's a lot of, especially in South Carolina, and especially in coastal South Carolina, construction defect and design defect litigation. There was probably a month ago, had a verdict, the Charleston County Courthouse for $55 million for a group of condominium owners involving a property in Mount Pleasant. That was built back in 1985, and everyone had pretty much assumed that it was sort of dead and gone and sat there for years and years and years. Someone came in and converted it to condominiums, and then had some design professionals involved in that conversion, some contractors involved. Those guys all got sued because they didn't do it properly, and ultimately it's a huge award. So have to unfortunately deal with that side of litigation, and sometimes you guys get roped into that stuff. Do you need a contract? Yes and no. You don't have to have a written contract. You can even have something that you have signed and the other person has not signed, or vice versa, and it can still be an enforceable contract. Under the law, contract is all about a meeting of the minds. Do you agree to do something? They agree to pay you for it. You have a contract. Now the question is it better to have a written contract? In most cases, yes, as long as the written contract says what we need it to say and doesn't put you in a hole. So good contract beats no contract, but no contract beats a bad one. So you always want to be thinking about when we're entering into these things, and I don't know how much negotiation you guys would actually do with the contract. Some of you probably had experience with that. But that's one of the most important things in a project, is not necessarily just getting the job, and obviously that's key, but you need to make sure that you're protected. And certainly you don't want to leave, you don't want to walk away from a good job, a good project, if it's over something that can be worked out. But on the other hand, you also don't want to be left hanging out to dry on the back end when you've agreed to a bad provision in a contract, and then we have to come in and help you try to get around it. So a good contract can be both a sword and a shield. You keep contract provisions, and you'll find a lot of these in the AIA documents. I'm going to have some AIA provisions up here in a little bit, but AIA, you could do a lot worse than the AIA. AIA is a group of, as you know, architects and other design professionals and owners, developers, contractors that get together and they decide what to put in these contracts. Not every provision in there is slanted towards the architect, nor is every provision slanted the other direction, but you could do a lot worse than going with the AIA contract. Chris mentioned to me that his projects aren't necessarily as big, so he doesn't necessarily need, in all cases, an AIA contract, but he still takes pieces of the contract and uses them in his, and I highly recommend that. But then again, do have someone look over it for you to make sure you're covered. You need your scope of services. You need to make sure you understand what documents are incorporated into that contract, because chances are it's not going to be the 2 pages you sign. It's also going to include general conditions, other documents. You want to negotiate your payment terms. We're going to talk a little bit about standard of care, which is just the standard under which you perform your work in South Carolina. That's big on the tests and the exams. Warranties, indemnification, dispute resolution, termination. We'll hit on all these. So your scope of services. Do you provide the same scope of services on every project? Probably not. So what you want to do is define your scope of services clearly in the contract. It's probably one of the most important things that you can do. Tell them what you're going to do, and sometimes tell them what you're not going to do. And so, for example, if you're doing design phase type services and they're not doing construction phase services, that needs to be in that contract. I would even highlight this contract does not include construction phase services. Too much is never enough when it comes to documentation. We'll talk about that in a little bit. Contract administration, I'm sure y'all probably have some experience with this. That's generally in the construction phase of the job. The owner hires you, pays you an additional fee as the design professional to sort of be in contact with the contractor and the owner to handle, you're handling RFIs, you're handling shop drawing submittals, and in some cases you're actually going out on site and doing inspections. So with all construction or contract administration, some people call it construction administration, you want to just do it or just don't do it, but in any circumstances don't just sort of do it. That's where you get in trouble. Probably over half of the cases that we get involved in defending an architect is not necessarily about the design, it's about the contract administration phase, which the architect got paid an additional $4,000 or $5,000 for, but doesn't have good documentation, wasn't on site when they were supposed to be per the contract. And that ends up coming back and biting them, and you can get in trouble just as much, if not more so, on the contract administration side as the design side. So if you're going to do it, make sure you go all in, and if you're not, make sure you tell the owner that you're not going to do that. So site visit observations, observe what you should and note what you observe, and that's where we get back to documentation. Too much is never enough. As you can see, this guy has gotten himself a swimming pool right by his front door, and I'm sure y'all probably seen worse than that. But the key is to make sure that you are putting in your file reports of when you were out there, what you looked at, advising the owner, advising in some cases the building department. If you notice a structural, like a safety type concern, you need to advise the building department of that. But in most cases, if you want to copy the contractor and you want to copy the owner on all your reports, and make sure to do a good job of documenting when you were there and what you saw. So changes in the work, the contract documents and the work in place should look the same. Ideally, that's the ideal world. That doesn't always happen, and certainly as the architect, you're not expected to be out there 24 hours a day. That's what the contractor is for, and that's why he has superintendents and project managers. But egregious things, and we see them all the time, that people just miss and are out there and they're looking for one thing and not necessarily looking at others. And then you've got pictures in your file that show what you wanted it to show, but then also someone later points out and says, what about this over here? You didn't notice that. That's a problem. That doesn't look, that's not how you designed it. It's completely different. That's a problem. So sort of make sure you're not necessarily looking for structural type things as the architect, but you would be looking for major deviations between the contract documents and the work in place. Finally, when you're certifying substantial completion, which a lot of times you have to do in larger projects, don't say it's built right if it's not, just to get the project done. And the owner's going to be pushing you at all times and pushing the contractor. I got to get it done yesterday. It's got to be done. It's got to be done. You cannot afford to have yourself hanging out to dry when you certify substantial completion. So don't say it's built right if it's not. Pay applications. Oftentimes in larger projects, the architect gets the enviable job of certifying pay applications, which can also get you in some trouble. The lender has a pot of money. The contractor wants to get paid. He says, I've done X, Y, and Z. Architect, come out and verify that for me. So you go out there and part of your contract administration, you're looking at stuff. Yeah, it looks like he's done what he said he did. And you've all seen one of these. This is the AIA pay application. And this is significant right here. This provision that you're actually signing, that you say, based on site observations and the data comprising this application, I'm certifying to the owner that to the best of my knowledge, information, and belief, the work has progressed as indicated, the quality of the work is in accordance with the contract documents, and the contractor is entitled to payment. Most of the time, you're not going to get in trouble with this right here. What happens, this is the part you get in trouble with. The quality of the work is in accordance with the contract documents. That's not ideal, and of course, you're not saying that it's perfect. You're saying to the best of my knowledge, information, and belief, I reasonably think this. Just make sure, in conjunction with these pay applications, that you're documenting what you're looking at, and when you're out there and all that good stuff. So once you put your name on there, you have potential to be, you're basically telling them that the quality of the work is good. And people can have something to say about that later if the quality of the work turns out to be bad. So if you see something you don't like, question the contractor, put it in writing, put it in writing, put it in writing. So document any change to the work, contract sum, that's the amount of the job, and the contract time. Change in scope, just like with the pay application process or the substantial completion, don't be bashful, say it loud. Make sure they know when it's a problem, because if you don't, chances are you're going to come back 5 years later and wish you had. A lot of times when you deal with HUD, deal with some government and lender folks who are on not necessarily the owner side of things, but they're involved in the project. These guys have their own contracts, and they love to try to put stuff in there. The architect, this is from actual HUD certification that we objected to. Architects are responsible for ensuring that construction is carried out in accord with official contract documents. If you try to insure something, what does that mean? If it's not in accordance with contract documents, you potentially have a problem. Architectural design and supervision of the subject property. You were never doing any supervision. That's the contractor's job. So you see that provision in that contract, you got to raise that to someone's attention. It might say, I can live with for architectural design and other services as set forth in the contract, something like that, but you don't want to get in here where you're supervising something that you never agreed to supervise. AIA contracts, there's a provision in there that says the following documents are incorporated by reference, and typically it'll be like the A201, which is the general conditions. Y'all probably seen it. It's a pretty thick document, and that basically governs beyond the time, the money, and the scope of the project. That governs sort of your general dispute resolution process. It governs contract administration, how it's to be performed, how often it's to be performed. And sometimes they'll incorporate by reference the general contractor's contract into yours, or they'll incorporate, for example, a consultant. You might have an engineer, and their AIA contract might say, this is your deal, but also you're bound by the general contractor's contract and the provisions therein. So know what you're signing. If they say something's incorporated, ask to see it. Let's take a look at it before we sign it. Yeah, again, that's what we're just talking about. AIA documents can sometimes be modified. You can look at the cover page and you think that it's an AIA contract that you've seen a million times before, that the general conditions are things that you've seen before. Look through them. People will sometimes put slashes through them. They'll strike out little bits and pieces of them that can really dramatically change the effect of what you're working under. They can also, on a GC's contract, this happens a lot. The general contractor will typically have an addendum, which is like an addition to the contract, where they'll say, despite what the general conditions say, we're going to replace section 4.7.2 in the general conditions, and we're going to have it say this. So that's attached to their contract, yet another thing that's incorporated by reference. So your contract documents ultimately are bigger. The universe is bigger than just the 2 pages, 3 pages that you sign in the plans. What you don't read can hurt you, and if you don't feel comfortable reading it, hire someone like me to read it for you. We do that all the time, and it's a lot of times there's something really egregious that jumps out, and sometimes those things are not as egregious, and they're kind of subtle. So we love to help you out, take care, look at those things, and make sure you're not getting yourself in trouble. The schedule, always very important. Again, you'll have the owner breathing down your neck. You've got a project, you know where you want to get to, so let's have a plan to get there. So you got your destination, but there's all these different things that go into getting to that destination, and you're working with a lot of other people. You can't rush right. That basically, what I'm saying there is that your schedule only allows you to do so much. If you know that you can't do something, and you know it can't be done no matter how much time or money they give you, don't do it. If you know that the timing of the project, owner says, I need this delivered by X date, if you know it's going to be a problem, you need to tell them early. Another thing that comes up, during the project, you've all agreed on a specific time period in which the project's going to be done. You've done your design work, you're into the CA phase, but they want to all of a sudden go back and do some value engineering. They want to go back and have you redraw. So let's take a look at this part, and let's take a look, we'll have your engineering consultant take a look at this structural issue, and can we do this, can we do this? That can take a lot of time. And you need to advise the owner when you're getting submittal after submittal after submittal, and they're changing your work, that's going to change. I mean, you've got to take time to do that, and you can't rush that stuff. Where architects and engineers can get into trouble is when they start rushing to beat a deadline that was set before all these changes in the work started taking place. Yet again, document that. Tell the owner, I'm not sure we can do this in this time period. If we do this, it's going to be additional service, or we need to extend the time by X number of days. If it doesn't work, let them know early and often in writing. You don't have to be ugly about it, but you need to let them know in writing, because later on down the road, if you get sued and you get in trouble, we want to be able to look in your file and say, well, here's where we told the owner that it was going to take X number of weeks and it was going to go over the schedule, and then when the project doesn't meet that schedule, you know, somebody's upset, they lost a bunch of money, or you got liquidated damages from the contractor, and everybody's looking at you, and you say, look, I told you right here, and we agreed to this, and we talked through it. Key contract provisions, getting into your payment. Obviously, you want to negotiate what's best for you on that end. And I know y'all get paid way too little for what you do, and I hate that for you, but you need to make sure that your payment terms accurately reflect what you're doing, what you're getting paid for. You need to spell out, you know, we're basing this deal on X number of units if you're dealing with a multifamily type thing, or if it's a government contract. You need to make sure that they'll hand you contracts. Oftentimes you don't have a whole lot of leeway in the government arena, but you want to make sure that it clearly says what you're getting paid for and what you're going to do. Money might not be the root of all evil, but it's the entire plan of litigation. Amen. Everything that we do, obviously, that I do, is driven by money, and it might be payment disputes. So-and-so didn't get paid, or we're owed more money for this and that. The architect was asked to do some kind of additional service, or in some cases was not asked to do additional service, was handed some submittals, looked over them, approved them, and then wanted to get paid for that. And the owner said, "You never told me I had to pay you for that." That's a dispute over money that comes up all the time. There's liens that have to do with contractors' work. They don't get paid. You get sometimes dragged into dispute resolutions in those. And then, of course, your construction defect litigation, like my buddy who got a $55 million verdict. I'm happy to say I got my client out right before that trial in summary judgment. So we were dismissed, but that could have been a bad one. RFIs and change orders, you want to respond timely, be able to show you did, document what you looked at, when you looked at it, and sort of what your thought process was on that. Submittals, never ask for one you don't need, or review one you didn't ask for. That's where you get in trouble asking for payment for something, and they'll ask you why you did something you didn't ask to be paid for up front. Always return what you reviewed on time, be able to show what you did and when you did it. Document, document, document. Additional services, owners love to do that. They throw, well, can't you just take a look at this, and can't we just change this around? And if you don't negotiate it up front and tell them there's going to be additional fee associated with that, good luck getting paid. Payment issues, beware of your deadlines. You see something creeping up, you got to always be cognizant of that, and I'm not telling you guys anything you don't know on that front. Standard of care. This is more of the legal realm. I deal a lot in this area, and so what the standard of care is how you're to be governed under the law by what you do. So you have a certain standard. It's not perfection. It's not arbitrary. It is based on what a reasonable architect in good standing under the same or similar circumstances would do. So you've got an architect. Obviously, there's some debate about that. But what that's good for is it does not impose upon you the standard of perfection, which no one can meet. Also, it doesn't impose upon you the highest degree of care and skill which the human mind is capable. It's somewhere loosey-goosey in the middle, and there is debate about that. We'll have, a plaintiff's expert. You've all seen. I hope you've never been involved in a case like that, but you've all seen like the medical malpractice drama where they bring in some quack doctor who will say whatever they want him to say. They'll pay him his money, and he's the expert, and he'll say, oh yeah, this surgeon did so-and-so wrong. He'll say whatever they need him to say because he's getting paid. There are architects that do that. They don't do any design work. They make their living solely on forensic stuff, and after the fact litigation services. There's some of them in town that make a very good living doing this, charging $200-300 an hour to critique your work. If you're getting sued, they get hired by the plaintiff. They come in there and say, oh yeah, here, he screwed up all this stuff and he breached the standard of care. We would then have our own expert to be able to defend your standard of care. But the key point is that it's not perfection, and you want to set the bar at the right level. This is directly from the AIA, and it's really close to that was South Carolina law that I was showing you there. And that's taken from several cases as it's been developed over the years. AIA is basically the same. It says it's consistent with the professional skill and care ordinarily provided by architects in the same or similar locality under the same or similar circumstances. So yet again, not perfection, and not the highest degree of care, but somewhere in the middle. So never ever under any circumstance, if you leave today, don't remember anything I said other than this, I'll be happy. Never ever say you'll do more or better. Never as in not ever. You do not want to go in and say things like, in your contract, I'll exercise a high degree of care in accordance with the highest professional standards for providing this design and construction services. This is an actual owner's contract that they propose, and from the owner's perspective, they say, well, why not? Why wouldn't they give me the highest professional standards? That's what I'm paying them for. And the problem with that is you can't agree to a higher standard of care than what's set forth in the law because you run into insurance coverage issues, and that's a great way to object to the owner. Essentially what your insurer is going to say if you ever get sued, well, let me see your contract. well, I see here that you agreed to work with the highest professional standards, and you would exercise a high degree of care, you would warrant this, you would guarantee this. That's a problem, because the insurer is there to defend you for being negligent and for breaching your standard of care under the law. And this gets kind of esoteric, but the point is, you can always refer back to that AIA provision, which is a good one. You can always call an attorney and they can help you out wording these things. But if your owner ever objects to you objecting to this and has a problem with it, you just say, look, my insurance company, nor any insurance company, will cover me for this provision. It's a problem. Is an error, omission, a deviation from standard of care? No. No set of documents is perfect. No set of documents is ever going to be perfect. You're not held to the standard of perfection. There's a sort of a scale, and I can't tell you what it is because there's no hard and fast percentage, but a few errors and omissions can be chalked up to typos in some cases. When they get more egregious or they get a pile up and pile up and pile up, that might be leaning towards more of a breach of the standard of care. And frankly, that's what we litigate over. If you ever get sued for professional negligence, that's what we're arguing about. You know, we may say it's an error or omission, it's a typo, it's not. I had someone one time specify a window rating with a DP of 5, and the plaintiff's guys were saying, you know, that's absolutely ridiculous. You couldn't have a 5 DP window, and that's a problem, and that had windows other problems in this complex. But the point was, it was just a typo. But that taken with the litany of other things that my guy had unfortunately allowed to go into the plans made a bit of a problem for him. Don't set the bar too high. Your standard of care is not up there, it's not perfection. Set the bar at the right level. And it may ultimately be somewhere up in here. I bet I could even get over that one. Architectural regs, I know y'all have to delve into these as well. This is actually from the code, the architectural regulations, which sets forth all the licensing guidelines and the architectural boards and what have you. But this is a big one, and I just threw this in because yet another thing I want y'all to remember from today, from a practical standpoint, contract administration. A, I want you to document everything you do. B, if you're not doing CA, you have to report to the building department and the building owner that you're not doing that. The idea being that they're going to send somebody out or be a little more vigilant with their inspections from the county or from the town if you tell them that you're not doing CA. I've had architects get in real trouble with this provision, and it's kind of innocuous. It sort of gets missed by a lot of people. But if you're not doing CA and the owner doesn't want to hire you to do that and pay you the extra few $1,000s, you have to report to both owners. So just write a letter to the owner, write a letter to the building department. I have not been engaged to provide construction administration or contract administration services for this project. And it goes on to state what CA would be and what they expect you to do. And this, similar to the AIA, periodic site observations of the construction progress, quality, review of submittals, reporting to the building official and owner, substantial deviations. So they're not imposing perfection on you. They're not saying catch each and everything, because you can't do that. You being the architect, you know, you're not as familiar with engineering issues and structural issues and MEP issues. You might be, but you're not required to be. So you're looking at things that a reasonable architect would see, and you note those deviations. Going into warranties. This is an actual provision that an owner tried to put on one of our architects one time. It warrants that the designs and specs is prepared shall meet all applicable statutes, codes, regulations, and ordinances. It's a problem, because you're basically warranting. Once you warrant something or guarantee something, you're putting yourself out there, essentially certifying it. It is good, I said so, and if it's not, you can come after me. The only thing to be guaranteed is you regret any warranty or guarantee you make. Gravity is the only law that can be certified. It's funny, some code provisions you think are so clear and so crystal clear, you say, why couldn't I guarantee that this meets the code? I'm reading the code, here's what the document says, here's what the work is, it meets the code. There are cases, there's a great one in Georgia, it involved a shower door. This thing went all the way up to the Supreme Court, whether a particular shower door met the code or not. And so these guys litigated about this thing forever. It was a substantial dispute because it was over a multifamily complex and they had hundreds and hundreds of these doors. But ultimately they go to the Supreme Court in Georgia and you have 4 judges interpreting the code as meaning one thing, 3 judges interpreting it as another, and at the end of the day, what should have been a crystal clear provision, the architect said, yeah, absolutely, that's clear, that meets it. Even those guys can't agree on it when it goes all the way through the court system after 6 or 7 years of litigation. So the point is, try not to ever certify, guarantee, or warrant anything. We talked about this earlier. If you start doing that, if you have in your contract that you're going to warrant or guarantee something, your insurer is going to look at that contract if you ever get sued and say, sorry, you're on your own, because I cannot cover you for you deciding to undertake to guarantee something. That's not what we cover you for. We cover you for breaches of the professional standard of care. Under law, a warranty or guarantee like you did is not covered. And what happens when you fly solo? Man, it's a bad day. So better provision would be that you'll exercise professional care and judgment to design in compliance with requirements imposed by governmental authorities. And what that's saying is, again, what's your standard of care? Professional care and judgment. So I'll act within my standard of care to design in compliance with the requirements, but I'm not guaranteeing that everything that I do or my consultants do meet the code. You're not required to do that under law, and if somebody's pushing you on that and has a problem with it, that might be a job you need to walk away from. There is an implied warranty always with what you do to third parties. Implied warranty means it's not spoken. I'm not saying in my contract that I expressly warrant that all these documents in the construction meets code and that the construction meets the documents. Implied warranty is simply there to protect owners and innocent home buyers. If there's some egregious error in the plans, the owner can say, look, the architect has an implied warranty that he's going to put forth a set of plans that are workmanlike and that can be constructed, and that, in other words, you don't have a balcony that's not supported by anything, and the document collapses and it's a problem. That can be a breach of an implied warranty, because you putting it out there. This doesn't happen a ton. Mostly it's on more on the negligence side. But if you're putting plans and specs out there, which you do, you impliedly warrant their sufficiency for the purpose in view. Let's get back to our. What goes along with warranties a lot of times is indemnification. And you'll see these provisions, and indemnification is essentially that you agree to indemnify, to pay the legal costs, to pay any judgment assessed against the person you're contracting with. And how this will come up, you've probably seen a provision like this. You warrant the designs, we just talked about that. You will indemnify the owner from claims and costs arising out of errors and omissions, arising out of your work. So the owner wants to be protected. He says, to the extent I get sued by something that you did, I want you to indemnify me. I want you to take care of it, which means you pay to defend me. If I get a lawyer, you pay for it. If I get popped in court for a judgment, or if I pay a settlement, you got to indemnify me and you got to take care of that. You got that obligation because it's arising out of your work. Well, that's not an uncommon provision, and a lot of times it'll go both ways. You would be able to say, in an AIA contract, there's also a provision where the owner will indemnify the architect. But what you don't want to do is indemnify for errors and omissions related. So you need to have some sort of limiting language. And how do we do that? It's a deal breaker. We want to say, we will indemnify you to the extent we were negligent. So not to the extent, we're not going to indemnify you to the extent that a problem arises in any way, shape, or form out of this project or arising out of our drawing. We'll indemnify you, however, if we've done something negligent, if we've breached the standard of care, we can agree to that. We cannot agree to indemnify blanket for anything and everything under the sun. And again, your insurance carrier is going to have a problem with that because they're not going to pay for that. Equitable indemnity, that's basically if you don't have a written indemnity agreement between you, and you'd have one between you and your consultant, so you and your engineer, to the extent they do something that causes you to get in trouble, you'd want them to take care of that and make it right. That's only fair. Well, if that provision was not in your contract, you fall back on something in South Carolina called equitable indemnity. Equitable just means fair. The problem with equitable indemnity, the court looks at it and says, yeah, that's fair. If they screwed up, They should pay for it. They should take care of it and make you and do right by you. But the problem is, the court also says, if you, architect, have done anything to cause the ultimate harm, whether it's 1%, half of 1%, and you're at fault at all, you don't get equitable indemnity from your consultant. So the moral of the story is, I mean, that's a pretty dicey and stilted proposition there to take that on. So what I would do is have a written indemnity agreement that you can live with between you and your consultant and between you and the owner. And most of the time, that's not a deal breaker, but if the owner is seriously pushing that down your throat and says you have to indemnify me for anything and everything under the sun, you can't agree to that, because you're going to be looking down the road, you get sued, your insurance company wants nothing to do with it, and all of a sudden you're out there hanging, and you better have some money in your pockets when they come calling. Dispute resolution, typically these are kind of provisions you'll see in there, attorney's fees provisions, which says, you know, if we get into a dispute, architect will pay the owner's attorney's fees or vice versa to the extent they arise out of negligent acts or one or the other. So just look out for that. You try to strike those if you can, because attorney's fees can get pretty expensive. Present company excluded. Forum selection clauses, that just says where are we going to litigate this case. If you've got a company from out of state that's soliciting bids for a project and they're approaching you for being their designer or architect of record, their forum selection clause might require you to litigate in Massachusetts or California or Texas. That might be a problem, because you don't want to be forced into something where you don't do business and you're not familiar with that area. You want to just say, hey, forum selection, why not we do this in South Carolina, or why is there any reason we can't do it somewhere closer to home? Litigate or arbitrate. Litigate just means court, the courthouse down the corner, that would be litigation. Arbitration is sort of a private court, where you've got an arbitrator who is your decision-making guy. If I'm the arbitrator, you guys contract that you're going to arbitrate all your disputes. You come to me, and generally 9 times out of 10, I just split the baby. You present your case, they present their case. I get you to try to work it out. If you can't work it out, I say, all right, here's the deal. You're 50% at fault, you're 50% at fault, and so you each, you sort of wash out. And sometimes it's 70-30, and sometimes you get, it could be, one party's not at fault and the other is. The problem with arbitration is you don't have any appeal rights. So when you agree to arbitrate a dispute, that means that whatever that guy decides on that day, you're bound by that. There's typically not an appeal process, whereas litigation, if we go down to the courthouse and we try a case for 2 weeks and is a bad result for you, we can appeal that to the Court of Appeals, and if we have a bad result there, we can ask to appeal it to the Supreme Court. And so you have a lot more options, generally litigation. I'm not in favor of arbitration unless it's a really, really low dollar kind of project. Anything, in the hundreds, thousands of dollars type project, any sort of sizable thing, I would lean towards litigation and not arbitration, but that's just my personal preference. There are good arbitrators, and it can be a lower cost way to get done with things. Litigation is very expensive. Arbitration is sort of a condensed microwave litigation process, but you don't have the jury. You're not going in there in front of 12 of your peers. You're going in front of one guy who may have had a bad day, may have woke up on the wrong side of the bed, and you may end up paying for that, and you have nothing to say about it because you've agreed to it.
Where does mediation come in?
Mediation can come in both of these. Mediation is a dispute resolution process, but there's nothing binding about it. Both of these are binding. Mediation is where you both agree to mediate the case. You hire a mediator, who in some cases may also be an arbitrator by trade or by profession. But that mediator just meets with you, and generally you get together on a certain day. He put you in one room, the other party in another room, and he's the broker of the deal. So he's going back and forth and saying, look, here's the problems with your case. He's impartial. He's not deciding anything. All he's trying to do is broker a resolution between you. So you will almost always mediate in these big type construction defect cases. And a lot of times in an arbitration, you'll have a mediation. And more often than not, that's the parties agreeing to do that, because again, settling the case, obviously you save some money settling it, ending it early rather than going through the end of the process. But the good thing about a mediator is he's not binding, and everything you say to him and in that proceeding is privileged and can't be ever used against you. So there's really no sense in not mediating, at least giving it a shot. Construction, design defect litigation, again, this is what we do a lot of, defending design professionals, and it can get kind of hairy. These are the type of things that we see every day. And more often than not, these things in Charleston and coastal South Carolina have to deal with moisture intrusion. We all know that this is not a great area for any longevity of building materials or claddings and roofing, and you really have to watch and have somebody out there being vigilant about what's going on, particularly in regard to windows, roof, wall terminations, anywhere where you could potentially have water intrusion in a particular area. Pay really close attention to that, because when we see this stuff, these pictures could be from any one of 30 files on my desk right now. Window flashing issues, there's where your wall comes in, your roof wall intersection, they'll kick out flashing, and the water just pours in, and that's OSB board obviously, and it destroys it. And so what the plaintiff says is, look, this is structurally unsound. This was a breach of the standard of care of the contractor, because he went out and he built this thing and he didn't put flashing there like it calls for in the plans, or he didn't put Tyvek in a certain area, just left a gap, water's just funneling down there. That's a problem. So where do you fit into that? Well, one, did you put accurate flashing details in your plans? Or did you say something like, contracted to flash according to industry standards? That might be a problem. That's sort of rolling the dice. If I were you guys, things have changed a lot in the last 20 years. I mean, it used to be that you could take a set of plans and a builder would know how to build things, and it would know how to flash a window, but you get to the point where there's so many different kinds of windows, and there's so many different kinds of flashing materials. Waterproofing is a perfect example. On a deck, there used to be one or two different things you could do on a concrete deck, or a petty guard, or one of those type of systems, and everyone knew how to install them. Well, now you've got dozens of those systems, and some of them have varying installation instructions, and you need to either specify what you want them to use or give them a choice between one or two, and say, install in accordance with the manufacturer's instructions for this particular manufacturer, this particular product. It's hard to get in trouble that way. And then as far as windows go and flashing details, I would put a little isometric little detail if you're doing a window on how to flash a window, because the contractor will come back. We know that he knows how to flash a window, but guess what? If he gets sued and he comes back and says, well, it doesn't show me how to flash it there, and so I just did the best I could. Now, he's got a problem there, but you may have a problem there also. So I would recommend, maybe getting a little stock, little isometric detail of window flashing for a flanged window, and then for other kinds that you can insert in your drawings. And just pay careful attention to windows, to balconies, to any kind of overhang type areas. If you've got inset windows that are that have a little return on them, a stucco or something, make sure you've got a good waterproofing and leak mechanism on those things. That's where 90% of these problems happen, at windows, at balconies, and at roof wall terminations. Decks, all the time, always a problem. This particular deck, I believe, was a concrete T-bar system up here, and the underlayment there didn't stretch all the way to the T-bar, so essentially water's getting through it, traveling down, and then just dump straight into the framing, and then you get all this damage, and that's all got to be replaced. And it's not cheap to do on a 16 building complex. Who's to blame? Brace yourself and round up the usual suspects. We see it all the time. They're going to sue you, they're going to sue the contractors, they're going to sue the engineers, they might sue the consultants directly that you had. Everyone goes down with the ship. So this is typically what it looks like. Sometimes when you get in mediation, this is what it looks like. Everybody pointing at everybody else. I heard a plaintiff's lawyer one time tell me that that was his favorite thing when he would go to court. If he'd take one of these cases to trial, where if you had an owner over here with his one lawyer, he says, look, these guys completely screwed up my project. And you have all this group of guys over here who are all lawyered up, and they have their suits on, and they immediately start slinging mud back and forth. Well, it wasn't me, it was the structural engineer. Structural engineer says, well, I only did what, based on what the geotech said, and I knew I could do this and this. And so he said it's like roaches scurrying in a room, and you turn the light on. He said, look at them over there, like roaches scurrying around, because everybody's pointing at each other and sort of just running around amok like a food fight. And it can be bad. So you need to, and then again, that's where your documents come into play, and they help you out when you delineated what you're going to do, what you're not going to do, what you're delegating to other folks, etc. Contractor's favorite defense is going to be that you should have stopped me, which is, you had CA and you were out there and you saw X, Y, and Z based on your pictures here. I can see it in the background of this thing that they're all complaining about it. You saw that and you didn't tell me, you should have stopped me. He doesn't get very far with that defense, and he's still going to have problems. Problem is he's dragging you down with him. Talk a little bit about value engineering. You know what value engineering is. When the owner is basically saying, look, you've got a great set of drawings, you've got a great concept, I want to save some money, how can we do that, and then how can we sort of tweak some of the process. we're going to take out of the architectural realm, we're going to say a football game. I went to Clemson. I'm a Clemson guy, so any of you Gamecocks don't hold that against me. But we go to a lot of football games. Sometimes they're bad weather. Typically not cold enough where you need to wear one of these guys. But if let's say I'm going to a football game and I know that the weather's going to be bad, I know it's going to be raining. I'm looking, and my first design is I'm going to have one of these jackets here, about $370 a pop. So I'm going to have one of these, and I know it's going to keep me dry, I know it's going to keep me warm, and I can enjoy the ball game and the tailgating and whatever. But start thinking about it, really, I could save some money if I went with one of these rain suits for $14.75. I don't look as cool in this, but, well, maybe. Save a little bit of money, and then I have some other funds to put towards something else. So then, just get in my head, well, listen, I can invite some buddies. If I get the best raincoat over there at $370, and I get my 6-pack of beer, this is just me here. My box of wings, I'm over budget by $131. But if I get those PVC suits, which will still presumably keep me dry, get a couple of cases of beer, buckets of wings, and a motel for the night, I can invite some buddies with me. Then I'm the hero, and I take them all to the games, so don't worry about your beer, don't worry about your wings, and I got you a place to stay. We've done that for $180. So I've got $70 still to play with. That's looking pretty good. But if I'm looking further and saying, you know, I could probably do the same thing as far as the jacket with one of these ponchos for $2. I can carry this around as the size of a pack of cigarettes. I can roll it up in my sleeve. I'll be good to go. One size fits all. I can buy these for my buddies. I can bring more people and still have my presumably waterproof poncho. So again, looking at my $250 budget, I got my contingency here that we just looked at from bringing all my buddies, but then I get a bunch of ponchos. I can get a keg, a couple buckets of wings, pork rinds, you can stay at Holiday Inn instead of the Motel 6, and then have a Pepto-Bismol, and that still leaves me $5 left over. That's probably the option we're going to go with. I'm thinking that looks good. I can take a bunch of my buddies and I'll be the hero. This is what you end up with. So, and I skimped on the most important thing, which is the waterproofing, to get all my other stuff that I wanted to pursue, and in doing so, end up with a not so good project and a pretty gaudy fanny pack there. So the devil's in the details, and that's both with drawings and contracts. Again, drawings, flashing details are just so key, and that's what we litigate over so much at the time. Contracts, make sure if you're not comfortable looking at it that you hire somebody or ask somebody to take a look at it, because there's some details that can cause you some problems. Try to control the process rather than letting the process control you. I mean, that's sort of self-explanatory. And most importantly, don't do anything stupid. This is one of my favorite photos when I found this, and I still don't know if it's been photoshopped. I imagine it has to have been, but it's sort of not out of the realm of disbelief that something like this could happen. These poor guys out there looking at the plans. That's trouble. Don't do anything stupid. So this is our goal. You know, this is you and the contractor and the owner and your consultants, and everybody's living in harmony and holding hands. That's not going to happen. But let's get closer to this than that food fight that we saw before. And one of the ways to do that is to document the file, make sure your contract says what you need it to say, and make sure that everybody's on the same page. And if you've got a chain of communication going between you and the owner that the consultant needs to be involved in, bring them in. Make sure you have a signed agreement with your consultant. It's real easy to sort of slip into a informal relationship with a structural engineer that you use all the time, and you call them and say, hey, I need plans for this, and here's the loads forwarded to me, this is what you need, and then you never have a signed contract. That can potentially be a problem. You don't want those guys ever disputing later that they, contract says this, but I never agreed to that, I didn't sign it, and then you're left saying, well, we had an oral contract and you did agree to it. You're fighting about it. No reason to do that. If they sign something that says they'll do it, they should have done. Moving on sort of from that's kind of my spiel on the contracts and the litigation side. Real quick, I wanted to give you all just a little background on insurance coverage. This is more of a real world application. This is something that you're all going to need to do if you're not doing it already. I imagine some of you probably have coverage. But when you're in the realm of the working world there as a design professional, you need to have a good insurance policy. There's some differences in insurance policies between what you guys would have and what a contractor would have. You got what's called a professional liability policy, akin to an attorney, an accountant. Professional type folks have that same type of policy. A CGL policy is a commercial general liability policy. That's what most contractors have. And there's some really big differences between these. Yours will be a claims made policy, which means you get sued in 2012 you get sued this year, what's gonna, for a project that happened 5 years ago, what's gonna cover you, what you have right now. Whenever the claim is made, that's what covers you. So an architect's asked me, well, I'm going out of business, or I'm going into the real estate game, and do I need to still have insurance? The answer is yes, because if you get sued down the road for something that you did years prior, what's gonna kick in on coverage is the coverage that you have in place at the time you get sued. A contractor, you have a lot of fly-by-night sort of stucco subs, and we represent some of these guys that we'll never meet because they've been over here, they did the job in 2004, they had their insurance coverage, and they've since skipped town, the company is no more, but that insurance company gets put on notice of a project, let's say lawsuit 2014, your policy is gonna be this one, their policy is gonna be what was in effect back at the time of the work. So insurance company may call us and say, hey, I need you to defend this guy, but we'll never get to talk to the guy because he's long gone. So always be cognizant of sort of what you got in your rear view mirror, or what you've moved on from when you're looking at whether you need to still have coverage or not. Coverage and exclusions, not a lot of exclusions here. Exclusions means ways for the insurance company to avoid paying on your behalf. Claims made policies typically do not have as many exclusions. Contractors' occurrence policies do have a lot of exclusions. What do I mean? Exclusions would be like, this is one that took me some years to get my head around. A stucco subcontractor, for example, with a CGL policy, that carrier, insurance carrier, will provide him coverage for damage that his work does to other work, but won't provide coverage for his own work. Meaning, he puts up the stucco and does a bad job, you get water intrusion and you get a bunch of framing rot, they'll pay for replacement and repair of the framing rot, but they're not going to pay for pulling off the stucco and re-putting it back because that's his work. It's odd, it doesn't make much sense, but that's a particular exclusion, and what those mean for you is that when you're trying to resolve one of these big cases, and you got all the food fight going on between the contractors and the design professionals, these guys are the ones that the insurance company is going to be saying, well, we got these exclusions and we can't pay and this and that. So who becomes the easy target for the money, because has the easiest route to coverage, is you guys. So it's important, again, to have good coverage. Your deductibles typically going to be more so than the CGL policies don't usually have deductibles. You will have a deductible, but what that buys you is, so that might mean for the first $50,000 of a claim, or $25,000 of a claim, you pay it out of pocket, then the insurance company starts kicking in. But what you're buying with that is a lot of flexibility. You generally get to pick your own attorney. You generally get to have a lot more say in what goes on with the litigation, whereas these guys, they don't really have a whole lot of say. The insurance company calls all the shots. You're represented by who we tell you you're represented by. You want to settle the case, if we want to settle it, we're going to settle it. We don't care what you say. You have input into that. So limits, too much or too little, that just means how much you're covered by. I have clients who have $5 million insurance policies and might not need $5 million insurance policies, but guess what? They get sued a lot. Why? Because they've got a big pot of money that's easy to get to, and those guys, that's sort of inviting trouble, having too much insurance when you don't do that kind of, that much volume of work or that dollar amount of work. Too little can also be a problem. If you've got a $100,000 policy, that's not going to cover you for very much this day and age. So you definitely want to be somewhere cognizant of what your projects are, the worth of the projects, and what you're likely to get hit if something came, if the stuff ever hit the fan, so to speak. Your balance in your insurance policy is going to decline, meaning that if you have $1 million insurance policy and you go to court, or you get sued, your coverage diminishes based on the attorney's fees. So when you say you have $1 million in coverage, you might at the end of the day only have $800,000 to satisfy a judgment because the attorney's fees come out of your limits. There again, you want to make sure you have enough to cover that stuff. If you have a $100,000 declining limits policy and you run through a 2 or 3 year lawsuit, you don't have much left to satisfy a judgment if something gets verdict goes against you. Settlement, again, if you're going to settle a case at mediation before it goes to the end of an arbitration or before it goes to trial and the jury rules on it, a lot of these cases end in settlements and you get the consent on that. That's part of the reason you pay for deductibles, so you have some flexibility and you have input. That's why I love working with design professionals, because I actually get to have a client who has input on the allegations. As well, this is the reason I did this, and here's why we don't have this documented. And it's a lot more fun for me to work with someone like that than it is someone who I never get to meet and has no say on his defense. There's an impact on your future premiums. if you settle a case, X number of dollars, and that's something you talk about with your insurance carrier. You know, when you're looking at a policy, what's going to happen if I settle a case, consent to settle this? Is that going to make this carrier less likely to cover me next year? Is that going to make my premiums go up? Sometimes yes, sometimes no. Pre-claim assistance, I'm getting to the end here. Pre-claim assistance, whether it be self-generated or under the direction of your insurer, fight back. A pre-claim would be, you see something coming down the pipe, you've got contractor or owner writing you letters, hey, we've got problems, or we've got this monetary dispute. No lawsuit yet, but you can contact your insurance company and they will pay generally out of pocket on them. You don't pay anything on a pre-claim to investigate it, to respond to subpoenas, let them get involved as soon as you know that there's trouble coming down the pipe. Let them know, and you'll end up getting more bang for your buck, because most of the time a pre-claim is not treated as a lawsuit, and the insurance company will cover 100% of that. So if you have questions, and again, that's when you pay for a professional liability policy, you're paying for that's a big deal, and you'll have a contact at the insurance company that you can talk to. So with that, ran through that kind of quickly, but I'll make sure everybody gets out on Friday afternoon. So y'all have any questions? I know I hit a lot of topics there, but I hope some of that was helpful. Any questions? Yeah.
So drawings versus specs and discrepancies between the two, which would you say governs over the other, or would you say they're both?
They're both important, and that happens a lot. And most of the time, even the unreasonable folks on the side that's shooting at you will agree that you read them together. They're complementary.
Right.
So if a spec says one thing and the plan says something else, most of the time you can be covered by one or the other. But if ultimately the contractor does something completely different than either one, that's his problem. The other is that you could say, look, if you had a question about what the design intent was, you need to ask it. You need to submit an RFI. But you can have discrepancies that happens all the time, as long as they're not completely egregious. But if it's just minimal type stuff, it's not usually a problem. Because a lot of times people will use the same specs over and over for jobs, and I mean, it's hard. You got a spec book that big, and you've got a thick set of documents. It's hard to coordinate all that stuff. But ultimately, who falls in that chair is you guys. And I have architects all the time to say, look, this is something my engineer did. These are the specs that the civil engineer did. These were not mine. Well, the problem is they're so bad that you're seen as the captain of the ship. You could have some potential trouble for that, because you've got to answer when you're putting your seal on that set of drawings. You're telling them, you're saying, I take responsibility for this whole thing, and sometimes that can be a problem. So, spec-wise, I would definitely keep an eye out. I mean, if there's a way to sort of monitor those two together, and it's easier said than done, but I mean, try not to have discrepancies, but if you do, it's not the end of the world. Anybody else? No? Fair enough. Well, I appreciate the time, y'all. Thanks for letting me do that and have some of those koozies, and definitely give us a call sometime. We're right down on the end of Calhoun Street, and if we can ever help, like I said, we do a lot of contract reviews and negotiating, deals, helping you through stuff like that, and insurance questions. If you have those, by all means, call us. Love to help you out. Good luck on the test.
Thank you so much.